The state should not feel so threatened by people expressing their opinions.
To why the legislature thought when there was already an existing act which with punishing the exact same thing but also an inclusion in the BNS.
So if someone is lynched by a mob, not on the basis of the criteria given under the provision, will that not be an offence or will that be an offence?
But why has the parliament brought about this conflict on itself? I'm not able to understand.
So, but don't you think that this is in fact violative of Article 20 subclause 3?
Now the section itself is deleted completely, and this to my mind is somewhat problematic. In plain parlance, marital rape exclusion defies logic.
The biggest conflict which generally judges face is balancing equity and law.
We want a shift from punishment to justice, right? From dand to nyay.
Hello everybody, welcome to the second episode of Bridging the Gap by the Advocates Association of Western India, AAWI. Today's episode is a very interesting episode. It deals with a law which not only impacts but genuinely plays a very vital role in every person's life. It is a law which deals with crimes, offences and punishments all throughout the nation. The Indian Penal Code, enacted in 1860, has now been transformed or replaced by the Bhartiya Nyay Sanhita 2023. The new law aims to, in the words of the government, not really punish people but actually bring justice to the citizens. And therefore, this law is something which is going to impact every person throughout the country. And to discuss this law, we thought of no better guest than Justice Akil Kureshi. Sir has been a judge of the Gujarat High Court, the Bombay High Court, thereafter served as the Chief Justice of the Tripura High Court as well as the Rajasthan High Court. He has truly given justice all throughout the nation, and therefore he's somebody who has the sort of experience and expertise of different laws and different stratas of the society all over the nation. Apart from this, I must say that Sir is truly an intellectual. Sir is not only a judge, but he is a jurist because of his studiousness. And apart from this, Sir's calmness and pleasant personality truly will bring a contagious smile on your face when you're interacting with him. Sir, we really welcome you here today. It's a pleasure to have you here.
Thank you very much, Akshay. Thank you for kind words. Really, thanks.
Sir, in fact, what we've been told is that even beyond your legal career, you are a gold medalist in mathematics and also an avid horse rider. And even till date, you are somebody who follows this passion. And there's so many facets to your personality which we did not know. And we are so happy to interact with you today and have you here.
Thank you, Akshay. Thank you again. Maths and horse riding are two passions I could never grow out of. Okay. Early years, I was fascinated by mathematics as a subject and also horse riding. I still continue both the passions. Thank you.
So, and what do you feel about being on this platform here today, a podcast platform?
It's a very new experience. I've never been part of a podcast earlier. For more than 18 years, I was a judge. 2.5 years, I've retired. I've given many public speeches, addressed gatherings from law students to judges and public. Couple of times also on the websites. But podcast is my first experience. I feel I'm on a hot seat.
In fact, sir, by way of this podcast, the concept of this podcast is bridging the gap, where we young members of the bar call upon jurists and senior judges and senior lawyers to just interact, and so that our generation of lawyers to come, students, etc., are exposed to the expertise and experience which you bring into the table, sir. So that's our endeavor.
Bombesh, let me say two things. First of all, thank you for inviting me, because whenever I try to research for a talk like this in advance, it clears so many of my thoughts and ideas. It helps me immensely. Any one session like this needs me to put in effort, and that so many thoughts are cleared. So first of all, I benefit out of this. And secondly, and more importantly, it's so interesting to see youngsters like you and Akshay taking interest in things which are other than commercial laws.
Sir, before we dive into the topic, a couple of questions, sir, as Akshay mentioned. that you have literally imparted justice all across the country. Sir, how has your experience been in being a part of so many different high courts and Bombay High Court as well as the other high courts where you've been a part of? If you can shed some light for our viewers, how has your experience been?
Bhuvnesh, oftentimes people have asked me, which high court you find the best? And I always say it's impossible to compare different high courts and different situations and different circumstances. But two things I have seen which are uniform and universal truths. First, wherever you go, either as a new judge in your high court or in the same high court from one jurisdiction to another. Suppose you have always been a tax judge and suddenly go to criminal or vice versa. Or you go to another high court. The open gambit of the bar is a friendly handshake. Bar wants a pleasant, happy judge. Only a pleasant and a happy judge can impart justice and give you positive reliefs. So bar always offers a hand of friendship. It is only when I make a mistake, if it only I am not impartial or I am not above biases, then the bar changes its strategy. That I have found in all high courts. And second peculiarity I have seen across the high courts is that depending on the jurisdiction, the lawyer's approach and tendency are different. So tax bar will behave similarly whether it be in Gujarat, Bombay, Rajasthan or Tripura. Criminal bar will have its own peculiarities. And that's across all high courts I have found. Coming to Bombay, I was exactly here for 1 year, right? To the dot, we were here for 1 year. And that was perhaps the most challenging period of my career as a judge. In terms of kind of litigation, in terms of kind of assistance, in terms of work ethics. It was brilliant. I loved it. So Bombay was special in that sense.
So Bombay High Court is the best. We Bombay High Court lawyers love to believe that.
You can deduce that if you want to. I have not said it.
You have settled now in Bombay, so I think there's a little bit of a bias.
Yes, there is a draw. There is definitely a pull, a magnetic effect of Bombay, for sure.
Sir, throughout your career and especially as a judge, there must have been times where there were difficult situations where you had to, in the sense, impart justice, but also be within the four corners of law. And the biggest conflict which generally judges face is balancing equity and law. So how has your experience been, and how did you actually manage to maintain this balance between equity and law?
Excellent question, Akshay. Oftentimes people ask me, what are the difficult situations you encounter as a judge? Okay, and my answer always is that not a very difficult legal proposition or a constitutional challenge. It only requires you to put in a little hard work, burn a little more midnight oil, ask the lawyers to give you better assistance, more research. Sooner or later you find an answer in law. What more difficult situations are when you see law and justice do not converge. You find law is on one end of the stream, the justice is on the other. What do? Do I break the law to do justice? Or do I uphold the law and do injustice? And that's the most difficult situation in any judge's career. My philosophy is, or my proposition is, that out of 1,000 such cases, if you put in enough hard work, if you allow your mind not to boggle, if you try to find a solution to a problem, bend the interpretation, mold the relief, 999 out of 1,000 cases, you'll find an answer. It's just a matter of being more innovative. It's just a matter of putting a little more hard work and more imagination. Mostly you'll find an answer. But in the 1 out of 1,000 cases you do not find an answer, you uphold the law. Because in a collective system of wisdom that we adopt, you do not put individual wisdom ahead of collective wisdom. And the law framed by the parliament is manifestation of collective wisdom of the people. And so I think this law is not correct or not good, is not a good enough reason not to follow the law. It is therefore that our constitution empowers none other than the Supreme Court under 142 to pass any order to do complete justice. It is when the law does not help the situation, but the individual case is crying out for a solution, the Supreme Court can do. Nobody else can.
We require such sort of situations in our career to deal with as lawyers also, that we want to also help a client, but the law does not help us. I think in the end the judges are there for that.
I'll recount one case in Gujarat High Court. There was this person who belonged to OBC category.
Yes.
And he had the certificate and everything. But while filling up a form for medical seat, by mistake he said general. Now, the difference between general merit list and OBC merit list was massive. So from getting a free government seat to the best college at a very nominal fee per year, he ended up getting into a very low priority medical seat at a very high cost. And he came to the High Court, filed a writ petition. University obviously would not permit him to change. Last date gone, cut off everything. And at that time, the Supreme Court judgment was no further admissions after a particular date, 30th of May for certain seats and June or July for something. That was because every time it was overspilling. And the admission processes were going in a tailspin. So they said after 30th of May or so, whatever the date, no further admissions. And the boy came virtually at the last minute. And we passed an order. My team worked overtime to prepare the order. If it was not served on the university on that day, our effort would have been lost. At the end, I got very irritated with the boy. And I said, what kind of a mistake you make? Look, your parents, old people here, they're so worried. They're under tension. You know what he told me? That, sir, in my entire village, in my entire community, I'm the first one who is passing out of graduation. Nobody else is there to help me out. And I felt so nice at the end of the day to have helped a person in this manner. So these are the things. I'll come back to more talk on this later. This is what makes a judge's life worth living. It's phenomenal.
Yes, sir. So now talking about exactly this, what do you feel is the pro and also the con of being a judge in India? And also, how do you motivate this generation of lawyers to take up judgeship?
See, Bomesh, my personal experience I'll recount. And I'll also say what it entails being a judge, right? Total social seclusion, obviously a drop in income if you're doing fairly well. So much substantially more hard work. There is no comparison between a judge. I was talking to Justice Nariman, and somebody else also said the same thing. None other than Justice Nariman said that what I was doing as a lawyer and what I was doing as a judge in terms of hard work, there is no comparison. It's a pressure cooker system. And many people, the public generally of course, but even lawyers, do not realize what goes behind the scene. Okay, it's not just 11 to 5 matters, but you read the matters for the next day, you pass orders, correct orders which are dictated. There are committees and administrative responsibilities of a judge. So it's like a round-the-clock work. And there are no concessions. Somebody is unwell at home, I'm slightly under the weather. In the court, no concessions given. You have to be ready, you have to be razor sharp and try to give justice. But at the end of the day, the satisfaction is unparalleled. I cannot think of any other job, any other profession, any other vocation which can give you the same level of satisfaction of having done the job well. You are touching human lives every day. Smallest thing you do will touch somebody's life. A criminal law, you are walking on the razor's edge. If you hand down punishment for life, you are taking away somebody's 14 years. There are times when I was so disturbed when I found that the conviction by the lower court was completely, palpably wrong. And a young man was in jail for 4 or 5 years. When you correct it, you feel good, but when you look back, you feel so disturbed. Coming to encouraging youngsters to join, if you have within you to do some good for the society, if you can forego the lure of money, there is nothing that will give you this satisfaction. Even before I was appointed, there were controversies, twists and turns. For 18 years, there were many ups and downs in my career. And I'm not referring to further progress or personal gains, purely in terms of being not able to protect the system from people doing damage from within and outside was sometimes very frustrating, disappointing. But at the end, you can only do your best and leave the system to find its own corrections. So, despite all these twists and turns and ups and downs, not a moment have I regretted having agreed to be considered for the judgeship. And if this is good enough for youngsters, I think you should. To both of you, I would say personally, if a situation ever arises, don't turn it down. Don't pine for it. You cannot plan for it. Let it come by invitation. If the system thinks you are good enough to occupy the seat, my personal request to both of you as personal friends, don't turn it down.
Surely, sir.
Duly noted, sir. So diving into the topic, the BNS, before we go into the changes, we would like to know your general overview about this law, because there was a lot of discussion, maybe not too many parliamentary debates as it would be required, but a lot of discussion about this law, and it was promoted in a certain form in the media at least. Now, after we have the benefit of going through this legislation, what is your overview or your your just a basic understanding of what this law is?
Akshay, first of all, I had to shed my own bias for so many changes. At my age, I don't like such drastic changes, right? For me, for 40 years, murder was 302. Suddenly the number has changed. But having overcome that and having tried to study, listen to some discussions, read some literature, you see, we should not go by the percentage of things which are the same and percentage of changes which have come. Somebody said 80% is the same. Now, percentages don't decide how much it has changed. One or two very small changes can be so impactful or significant that the entire focus may change, entire trend may change. So let's not go by sheer statistics, number one. Two, the Home Minister, while introducing these bills before the Parliament, in his speech, had said two or three very important, interesting things. He said that we want a shift from punishment to justice, right? From dand to nyay. Second objective was to come out of the colonial mindset, right? These offences were, these provisions were made more than 100 years back by a colonial ruler. The purpose was different. In many provisions we find, for example, 124A was a dissatisfaction against the government established by law. Now it says from government to the country. So major change. And they say from Rajdroh to Deshdroh. That appears to be the change that is sought to be made. We'll discuss more about it. So this is a second aspect which has been presented to the Parliament. Third, the use of technology to speed up the justice delivery system as such. Forensic analysis, use of modern technology for recording evidence and relying on e-documents and so on. And a couple of other side issues such as giving a public servant sanction for prosecution. If it is not done for 90 days, it will go by default. Trying a person in absentia if he is absconding. So these are some provisions made to speed up the whole things. We will discuss all these provisions overall. And at the end, I'll leave it to the viewers how many of these objectives have been achieved. Where do we fall short? Do we need something more? But before we discuss all that, let me say one thing. I've always marveled at IPC and other provisions as well, but IPC more so because more than 100 years back, somebody had thought of every societal wrong that you can think of even today. If my neighbor encroaches my land, it's an offense. If I take away somebody's pen, knowing that this is not mine and appropriate, there is an offense. If I borrow somebody's money from somebody with full intention of not returning, there is an offense. For over 100 years, if you analyze the new editions of the penal provisions, they fall in two baskets. One are the same offenses but in more organized manner. So you have Terrorist Act, you have Gunda Act, and you have Makokas and so on. Same offenses. Not a single offense is new. It's just more aggravated form because it's more organized now. You have gangs and you have terrorist activities and such like. And second set of offenses which needed to be added to the existing ones are what the society now thinks is wrong, like NDPS. 100 years back, ganja and afim was not a taboo. We now realize that it causes so much damage to the society, so we have those provisions. Otherwise than that, these offenses have stood the test of time for over 100 years. And it's a marvelous piece of legislation, so precisely defined. And if you see the structure, if you see the scheme of the act, the definition of an offense will be provided, followed by the punishments. And punishments come in graded forms. Maximum 7 years if there is a theft, for example. If theft by nightfall, another higher punishment. If by housebreaking, another punishment. By causing hurt, higher punishment. And everywhere, in 99% of the cases, it is a maximum prescribed, not the minimum. A punishment which of the imprisonment of either description, which may go up to 7 years or with fine or both, or up to 10 years or with fine or both. So a judge can hand down punishment of 1 day if he thinks that the facts are special. It's very nicely drafted and something that has prevailed for such a long time. Of course, changes were needed, and let us see how the changes have been brought about.
So, the first change you'd like to discuss, and it has been a rather hot topic because of, unfortunately, the kind of incidents that have taken place maybe in the last decade at least, which has gravely affected the society, which is rape. And there has always been a need of more stringent provisions protecting the rights of women. And somewhere there they have sought to bring about these changes within the BNS also. One of the provisions was, which is very discussed very often of late, is the concept of marital rape. And in fact, there's a petition in the Delhi High Court, and there's a conflicting view, or the judges did not come to a unanimous decision about whether marital rape should be an offense or not. Now, despite all this debate, the law as it stands has continued, only with a little bit of a tweak. Could you firstly tell the viewers what is the change about in the concept of marital rape, or whether they've made it an offense or not, and what is your opinion about this offense?
Okay, as Akshay, as you know, earlier offense of rape, simply put, rape is a sexual intercourse or now wider actions without the consent of the woman or against her desire or wish and so on. Marital rape was excluded from this purview unless the woman was below 15 years of age. The Supreme Court, in Independent Thought versus Union of India, applied range of techniques to bring it to 18 years. They discussed the international literature, they discussed the Child Act, they relied on POCSO, and all those provisions put together. They said that we are not going to touch the exclusion of marital rape part, but when it says not below 15, it should be read as not below 18. Therefore, when the statute now, the section, I think 103, 102 defines and 103.
No, sir, 63.
63.
I'm sorry. 63 touches the aspect of marital rape. It only brings it in consonance with the judgment of the Supreme Court. It does not expand it beyond this. As I rightly pointed out, this is a debate which is ongoing. It is pending before the courts. And recently I read that the government has pleaded to the court that do not bring in the element of marital rape through judicial process. New act has maintained, means the parliament thinks the existing provision should be maintained. They also pleaded the court not to bring it through the judicial activism or judicial process. Personally speaking, well, I do not see how a husband can have a license to force himself physically simply because the woman has agreed to be his wife. So, in plain parlance, marital rape exclusion defies logic to me. I personally think the main reason why the parliament is hesitant in lifting the rigors or throwing this concept in the statute is it the complication of either proving it or disproving it. It happens in the confines of a bedroom. And it opens a Pandora's box for allegations which are going to be extremely difficult to judge the correctness of. Is it just a disgruntled situation which brings the allegation? Is it really what has happened? And all these things are probably running in the minds of the lawmakers, and therefore the hesitance in throwing the marital rape into the fray. But coming back to the situation, as a pure proposition, I cannot imagine how can a husband have a license to force a woman to have physical relationship against her desire simply because she happens to be his wife.
So also, in fact, I remember reading an article or I think a statement by the government which said that we can't introduce the concept of marital rape to preserve the sanctity of marriage. Similarly, in Evidence Act also we have provisions which preserve the sanctity of marriage, of confessions, etc. So that's also one more opinion of the government as to why they do not want to make marital rape a concept.
I've noticed that statement. I've not read the full affidavit which the article is referring to. So it would not be correct on my part to comment on one sentence which the article has said. But if this is what has said, frankly, I don't understand. And how does it maintain the sanctity of marriage? By allowing the husband to insist and go beyond insistence to demand physical relationship against a woman's own autonomy and autonomy of her body.
In fact, it is reported that the arguments of the Attorney General before the Delhi High Court, if I'm not mistaken, was that the wife has the option of divorce any which way. She has the remedy of seeking divorce if this is the situation. So, why include this as an offense when she has a remedy under the family law? And yeah, then it becomes very difficult to really balance it out. And I don't
Correct, but what about the divorce will happen later? What about the offense which is already committed once? Right? If you can avoid repeat offense. And that's also easier said than done. To walk out of the family home or a husband's house is not so simple. It has many complications. But anyway, these are broad thoughts and you cannot have final answer on this. But in the context of rape, if you permit me just one line, the Supreme Court has also appealed to the government to remove this, what they call the Romeo Juliet Love affair. This 18 years of age for giving free consent is, to my mind, causing havoc. It's a knee-jerk reaction to Nirbhaya's very unfortunate rape incidents in Delhi. But it has very serious repercussions. young boy and young girl, the boy happens to be just over 18, the girl has to be just under 18. And if they lose their discretion and do something which the society says is not correct at their age, should it be made into an offense? One. Now they have also removed the discretion to hand down punishment below 7 years for good and adequate reasons to be recorded in writing, which was there in the earlier law. So compulsory minimum 7 years of punishment for an 18-year-old boy who just got a little excited with a woman who was just 18 years of age. I think it's a very, very harsh punishment.
Because consent is immaterial when you're that age.
So earlier 16 years was the age, now it is brought to 18 years. And that's, in so many tribal areas, they don't know about the law. Their age of maturity is slightly earlier. And now, if she happens to be pregnant, and if she happens to be below 18 years, the law mandates the police officer, one, to launch a prosecution, two, to carry out DNA test. So even if she is carrying the child of a person, even if they want to marry eventually, he'll be in jail for 7 years. It's working out very, very harshly.
Now, talking about the offense of rape, we all know that earlier there was the mere act of promising to marry someone, and on that pretext having sexual intercourse with that person would amount to rape. Now the government and the legislature has now carved out a separate offense in the form of sexual intercourse by employing deceitful means, which does not amount to rape. So what are your views about this new provision which has been introduced in the BNS?
Bhumesh, if I recollect correctly, it's section 69, right? In my understanding, the legislature is trying to carve out an area where the offense falls short of rape, but it is premised, or the sexual intercourse is premised on certain false promises. Now let's analyze this position, okay? Earlier offense of rape never specified a false promise of marriage would amount to rape because of the judicial interpretation. A consent which is based on fraud or misconception of fact or fraudulently obtained is not a free consent. And for offense of rape, anything other than free consent would amount to rape. And therefore, series of judgments that a physical relationship struck on a false promise of marriage would amount to rape. Then the Supreme Court also refined this by saying that a broken promise of marriage would not amount to rape because the promise has to be false from the outset. Two people may get intimate, may develop relationship, may exchange promises of marriage, may lead to physical intercourse. Sometime later, things may go wrong. And there is no compulsion to fulfill the promise at the cost of being charged for offense of rape. And therefore, there are judgments. You have also pointed out some judgments in that context. Now, therefore, the law was very clear. A false promise of marriage from the outset would amount to rape if intercourse has been permitted on that basis, but not otherwise. Now, I do not understand what section 69 will add to this. Because on both counts, be it false promise of marriage or false promise of promotion or employment, they both fall foul of a free consent concept. Had they just stopped here, perhaps I could have understood that's a special category they are trying to create, which amounts to rape. But the section specifically says, which otherwise does not amount to rape. So how will this operate? I'm not clear, number one. Number two, they also said false promise of marriage by hiding identity, right? And that's another very problematic area. Identity as to what? Of the person's age, his family background, his religion, his caste. Hiding identity, obtaining promise of marriage by not correctly revealing what exactly the words used. Let's see.
69.
Yeah. Suppressing identity. Now, what do you mean by suppressing identity? Identity of what kind? And I'm apprehensive that not very many convictions may be achieved under this provision, but large number of allegations may come up. Right? A living relationship going wrong, a friendly relationship going sour. And that's why the Supreme Court judgment which you have pointed out,
Pramod Suryabhan Pawar versus State of Maharashtra.
right? There the Supreme Court has very nicely analyzed the whole situation and has put a lot of stress on the promise of marriage being wrong at the outset. A false promise of marriage and not something which has gone wrong later on. This opens certain windows for making allegations. And as you have seen in so many offences or so many provisions, the process itself becomes a punishment. Ultimately, conviction may not be achieved, but the man may be behind bar for a long time before he obtains bail. And that's what I'm slightly unsure about, slightly apprehensive about.
So this also brings one more question. Can the person who is in this situation, earlier it would amount to rape, of course, if the promise was from the inception. Can it still amount to rape? That situation, can it still amount to the offence of rape, or will that person will now have to be tried under Section 69?
To my mind, if there is a genuine case of a false promise of marriage to obtain a favor of physical relationship with a woman, it will still continue to be an offence of rape. Plain and simple, because that concept has not undergone any change. Consent has to be free. And a free consent can be only if it is based on correct facts and it is not on false promise, not fraudulently obtained. So if in a given case, the woman can prove that but for the promise of marriage, she would not have allowed him to have physical relationship with her, and that the promise was false from the outset, and it will still continue to be the offence of rape.
In addition to 69 or by itself?
69 would be outset, because it said does not amount to rape. And therefore, as I said, I'm not clear on how it will play out. But on standalone basis, it will amount to offence of rape, for sure.
In fact, Bhomesh drew an interesting analogy when we were discussing this. He said this is like murder and culpable homicide not amounting to murder. So now there's rape and there's sexual intercourse on the basis of a false promise not amounting to rape.
I cannot see any area where it will fall.
Yeah.
You see, that's exactly what my confusion is.
Yeah.
And so courts will have to tackle this situation and give some interpretation to this. But there is some dichotomy here, for sure.
So in fact, people who are coming out of original 375 by virtue of this judgment, now they will be punishable for 69. I mean, obviously not retrospectively, but in the situation that someone could have taken the defense of the judgment and saying that there's no promise since inception. I don't know, maybe they can still fall under.
But here also, Akshay, the promise has to be false.
Yeah.
Right? So that requirement will still attach.
Yes.
And therefore, it will be a sound defense to say that I neither fall under section 63 nor under 69.
One more provision now. These are the newly added provisions. But one provision which has been removed, or rather which was there originally, was 377 under the IPC. And now it does not find place anywhere in the BNSS. And especially in light of the judgment of Navtej Singh Johar, where they, in the sense, culled out an exception and said consensual unnatural sexual intercourse is not included, but non-consensual is still included. So what would be the impact of repealing or removing 377 totally from it as an offence?
It's a very relevant question, Akshay. As you know, and some of the viewers may not be, section 377, which prescribed punishment for unnatural offence, Supreme Court earlier at one stage in Nas Foundation took a very conventional view, said this law made by Parliament, we are not going to disturb that because it's validly framed law. It's not beyond the power of the Parliament to frame the law. The larger bench in the Navtej Singh Johar, in fact, it traces the roots to Delhi High Court judgment. Nas Foundation, Delhi High Court, Justice A.P. Shah and Dr. Mulidhar had put in a lot of effort to annul that provision. The Supreme Court reversed it. But later on, judgment of the Supreme Court took one step forward, took a very progressive view, And essentially what it said is that what two consenting adults do in the privacy of their bedroom, the law cannot reach out to that. Law cannot object to it. And therefore, for a small area of consensuous gay sex was decriminalized. 377 was struck down, will not apply to two adults having their own personal different choices. Now, the section itself is deleted completely. And this, to my mind, is somewhat problematic because it takes away the protection to men and transgenders who are forced to submit to such acts. The women below 18 years, rape offense will take care of it, POXO will take care of it. There is a boy below 18 years, POXO will take care of it. But a man above 18 years and a transgender above 18 years, when they are subjected to such acts, there is no protection left, and they are very vulnerable sections of the society. Right? People living on the streets, people who are slightly of challenged mental abilities, in prisons, and so on. This was quite necessary simply because not very many cases are reported should not be a reason for completely doing away with the provision, is what I personally feel.
So another interesting topic which has now been included, or an offence which has now been included in the BNS, is regards to mob lynching. We've had several unfortunate incidents throughout the country, and in many parts where in urban cities, in metropolitan cities, we are having such incidents where there's actually people being killed and people facing real pain because of false allegations and people hounding against somebody. So this whole mob lynching concept has now become very relevant in our nation, and I think they're trying to tackle this mob lynching situation by introducing 103.2 and I think 117.4 of the BNS. So what is your view about it, and do you think that mob lynching will, in the sense, be curbed because of these new provisions?
Akshay, this mob lynching provision introduction, to my mind, is a positive change. It was a societal evil which required to be dealt with. We have seen so many people suffering because of the mob fury, originating from range of factors, not necessarily going to. Tehseen Poonawalla judgment, Supreme Court nudged the lawmakers to think about it. Murder by itself is an offense, as we have seen when it happens at the hands of larger number of people. We have either the provision for unlawful assembly or people sharing common intention. But in mob lynching, this would fail because to establish common intention is not that simple. And therefore, while introducing subsection 2 in section 103, making punishment for the offense of murder, they have now introduced the concept of mob lynching. Interestingly, in the bill, the punishment prescribed was up to 7 years, or it can go up to life or death. And that would have created a huge dichotomy. For ordinary murder, it is life or death. For mob lynching, it is up to 7 years or life or death. So how can you have a lesser punishment for this? But the legislature quickly realized the complications it could create, and therefore in the final act, we have is the same punishment. The significant change as compared to the conventional offense of murder, I notice, is that mob lynching by 5 or more people acting in concert, which is different from, and I think it's a lesser or a lower threshold as compared to sharing common intention. And therefore, because it happens on the spur of the moment, though it goes on for a longer time than pure murder, which may happen very quickly. So it will be not very difficult to establish that 5 or more people were acting in concert. And therefore, to throw in vicariously the same responsibility of everybody who is acting in concert could be easier for the law enforcement agencies. Very positive step, very needed, and I hope It'll bring in some sense of control over such actions. Two areas where I feel a little more expansion was needed. When it says on the name of race, on the race of race, caste, background, etc., why is the word religion not added? That's one element. And second element is, why do we pin it down only for special reasons? Okay? Very often, mob lynching happens without knowing the background of the person. Okay? He's lynched not because he happens to be a Dalit person. It's simply because he's suspected to have committed theft. Or a drunken person finds himself at the wrong place at the wrong time. And some people feel that he's trying to upset the modesty of a woman at the middle of the night. And he's thrashed till he dies. Nobody knows whether he has committed or not. And in any case, in any society governed by rule of law, it is completely barbaric. So I do not know why it is confined to this. It can be expanded to include all kinds of mob lynching. So one, yes, it's a very positive step. Two, I hope and believe it's likely to have some sort of control. But three, it could have been expanded a little more to be more effective.
For all different offences also, not only these two offences. It could be
for other offences, and for just lift the rigor of proving that it was done because he belonged to such and such social circles or social background. So remove all that. A person is suspected to have committed theft. You see, Akshay, it just so happens that people who are at the receiving end of such treatment are typically of the marginalized sections of the society. But that's incidental. And very often it is difficult to prove that the mob did this because he belonged to that caste or community or that background. So just remove that requirement. Any person who is subjected to mob lynching, by other ingredients being satisfied, 5 or more people acting in concert, subsection 2 of section 103 should apply.
So that's quite interesting, because then just to think out loud, so if someone is lynched by a mob, not on the basis of the criteria given under the provision, he's just lynched, murdered in the sense by a mob, and will that not be an offense, or will that be an offense?
In the present circumstances, no. There are added requirements. So the plain offense of murder, vicarious liability will attach either if you can establish common intention, intention, or there is unlawful assembly. Both these requirements are diluted in subsection 2 of mob lynching, 5 or more persons acting in concert. But an added requirement of doing so on the basis of those requirements because of his background or caste or etc. So that's an ingredient which has to be established to take the offense within subsection 2 of section 103.
Sir, I have a slightly different take, because I feel like this subsection is fairly inclusive because it uses the word or any other similar ground, which can be interpreted into various and other things, like as you mentioned religion, and as Akshay mentioned any other reason. So do you think that because they use the words or any other similar ground, it becomes an inclusive definition to include all such scenarios as well?
Bhuvnesh, just thinking aloud, when you say or such similar grounds, the legislature is meant to have extended what the expressions are already used. Ad judice ad justem, as a principle we call. You can't throw in something which is completely unconnected. Right? So religion may be by extension of this. It's not specifically stated, but because he belongs to a certain religion, that could be one of the interpretation of any other similar ground. But to say there is none of these factors present, he is lynched only because, as I said, he is suspected to have committed theft, or he is suspected to or alleged to have teased some women. And without any of these ingredients established, it will not fall in subsection 2. It will remain a murder, but only those who are directly involved in the act could be punished, not as a mob lynching by extending and applying vicarious principle.
Sir, another major change which has been introduced is to the offense of causing death by negligence. which has been made much harsher, probably taken into account now recent cases we always often hear in the newspapers that like death caused because of rash and negligent driving. However, they have made two categories in that. One, if you report that incident, you get a lesser punishment. However, if you do not report, you get a higher punishment. So what are your views on this bifurcation and about this new provision which has been introduced?
Yes, as you rightly said, the causing death by negligence, Section 304B, the earlier 304A, earlier provided prescription for such offences. Now it is divided into two parts. Even the base punishment has been increased to 5 years up to. Hit and run cases they are trying to address through the second provision. I looked up, and across other countries also, hit and run has been looked upon as a graver offense. In fact, in America, certain states require a person to stay put, even if he has just caused damage to the property, and to report. Our provision, which has been introduced, is a very new provision, first time attempt. We'll have to see how it works out. But number one, it requires that it applies only in case of causing deaths by negligence. So mere injury is not covered under this provision. Secondly, if you do not report to police or magistrate, that ingredient is to be satisfied. So what to me appears is that if a person after causing accident reports to police or to the magistrate, he'll not fall in this hit and run category. And perhaps there is logic behind it, because in India we have seen that a person causing accident exposes himself to physical harm by the bystanders and sometimes a mob which gathers there. So the temptation to flee the place is always going to be there. This misses out a very important element of providing support or assistance to a person who has been injured. Okay, so in an accident, what has happened. You can't undo it. But in many cases, timely medical assistance could save life. And this provision is not addressing this situation. It puts a higher punishment only in case a person causes deaths by negligent driving. So, one, as I said, it's a good provision. Hit and run cases are increasing. We need to curb it. Across the world, many jurisdictions recognize this as a graver offense. But should it not have been also for causing injury? Don't run away after causing injury. And two, how does a person know that he has caused death by his action? He has caused an accident. What is the extent of injury? He does not know. And what happens if the person dies after 3 years? Has he committed this offense? These are issues which will come up before the courts for interpretation. But all in all, a positive change, a much needed change, will require some refinement through court interpretative processes, or maybe the legislature also can revise the situation after some time.
So, but don't you think that this is in fact violative of Article 20, Subclause 3, which every accused has a right against self-incrimination? Here, the statute is compelling you to go and tell the magistrate or the police that I have committed this crime, but I'm coming to you. Don't you think this can lead to a violation of that fundamental right?
It's an interesting thought you are presenting, and surely it will be debated before courts. But number one, as I said, this has stood the test world across. That is one aspect. Second aspect is that he does not have to go and say that I've committed an offense. One argument in favor of this provision would be that by escaping from the scene of incident and not reporting to anybody, is it destroying the evidence? Because he may be under intoxication, under influence of alcohol. Being found after 2 days eliminates the possibility of nabbing him or showing that he was drunk at the time of causing the accident. So one logic in favor of the provision is that in the process, a person who is running away may be destroying the evidence of the offense, which itself is not permissible in law and it's itself an offense. But you're right, this will have to be debated before the courts.
So, speaking of the new inclusions, interesting inclusion is the provisions of organized crimes, offences of or punishments for organized crimes and crimes committed by gangs and in the organized form. We already have state laws like the Makoka, and every different state has their own laws. Now, this being a central legislation, is seeking to punish offences of organized crime throughout the nation. So, what do you think would be the result of this, where there will be a conflict between the state law and the central legislation, especially in light of Article 251, which specifically prevents this situation?
You see, Akshay, as you said, such local laws have been framed by many states. Maharashtra for one, Gujarat is another. I think Rajasthan also has its own law. But nationwide, there was no uniformity. And many states have not formed these laws. Perhaps the legislature, the central legislature, the parliament thought that there is a need nationwide and therefore these provisions have been made. Section 111, yes. I think, right? Now coming to the conflict between the two, Article 251 addresses a situation preceding Articles 249 and 250. 249 is where more than certain number of states by 2/3 majority yield to the central legislation. And 250 is where the emergency situation. As you know, the Constitution of India is quasi-federal. The strong union, but federalism is also present. But at times of emergency, it becomes a unitary structure. All powers are centralized in the center. And it's a beautiful framework that the Constitution framers have made. But this situation would fall under the later provisions of Article 246 onwards, where because the criminal law falls in a concurrent list. Because it is concurrent list, in case of conflict, the central legislation will prevail. More so, because the central legislation has been framed after the states have framed. Sometimes, as you know, there is a legal debate. There is a central legislation on a concurrent list. The state later on frames a law which entrenches on the central legislation, but because it is subsequent, and if there is a requirement of presidential assent, and when the president has granted such assent, should it not be seen as the state legislation prevailing over central legislation, and central legislation should yield to the state legislation? But this situation, as of now, will not apply here because the state legislations are already in place and the union legislation is now framed the law. So across the country, if there is a conflict, the new law will prevail.
Sir, but I mean, as we all know, all these MCOC, etc., are also a code in itself. They have specific procedure for trial, for investigation, for bail, etc. Same is not the case here. So, as you mentioned that if there is a conflict, central law will prevail. Then what happens to the already existing state law? Will that be overruled, or will that have to be struck down in light of this for offences to come?
I don't think there is a need for either overruling or striking down. The courts always try to harmonize the two situations. Unless there is trenching, unless there is overlap, they will try to find if there is both laws can coexist. But if it is simply not possible, the central law will have to prevail. But you're right that special provisions and mechanism or machinery has been made in the state laws. And that is going to be a bit of a challenge, because if the central law is applied and if prevails because of the conflict, I don't think the state machinery made for those provisions can also be applicable. Then you will have to go by the normal provisions for trial, for bail, everything.
Now, sir, similar situation in the next section which has been added, section 113, for punishing terrorist act. We already have another act of UAP, Unlawful Activities Protection Act, which is already in place, which is also a central act, and yet the legislature has chosen to introduce this fresh section. Sir, any inputs as to why the legislature thought, when there was already an existing act which with punishing the exact same thing, but also an inclusion in the BNS. Why would that be an intent of the legislature to put that?
Honestly, this is the most intriguing provision of the whole new law. And I'm at loss to understand the purpose behind introducing this. In the bill, there were significant changes. And I'll try to find out and see what exactly the words were. The clause 111 of the bill was a person is said to have committed a terrorist act if he commits any act in India or in any foreign country with the intention of threatening the unity, integrity, and security of India. To that extent, it's parallel, same as in the previous act, as well as in the new act. But this is what was there: to intimidate the general public or a segment thereof, or to disturb public order by doing any of this. This group of words are very significant because it lowers down the threshold from UAPA provisions. Had this been maintained, for whatever it is worth, there was a sound reason for introducing in the act. And my first reaction was, if this was so, the new act, that is section 113, would widen the scope of the terrorist act as compared to UAPA. But now verbatim it is the same. The offense, the definition is the same. Prescribed punishments and the situations where graded punishments are prescribed are the same. So I'm really not sure why it was done. It simply defies logic to me.
So in fact, even the conflict between a special statute and a general statute, and then in this situation, which one would prevail, or which procedure would prevail?
The first reaction would be obviously the special statute would prevail. But why has the parliament brought about this conflict on itself? I'm not able to understand. I don't see any purpose of the identical provision standing in two separate statutes, both framed by parliament. One is a special statute, another is a general. I'm not clear on this at all.
Most discussed topic when it comes to politics, which is the S word, sedition. The S word has been a very debated topic since over 100 years. I mean, even before we received independence, it was a very hotly discussed topic. And thereafter, the people who did not want this provision in the end also promoted the provision. And it continued. And there has been use and misuse of the provision, as we all have seen. Today, there is you can say not so much of a change, but it appears to be a major change eventually, that although they have not removed the provision of sedition from the criminal being a criminal offence, section 152, which has been added in the BNS, appears to have a little bit of a tweak, and that tweak could have a resounding effect, because they've replaced the word government with the word state, I believe, the sovereignty of the state. So what do you think will be the effect of this change in the law of sedition in our country?
First of all, Akshay, let's have a very brief look at 124A history itself. It is an offense which has stood for more than 100 years, made by the colonial rulers. Therefore, affection to the government established by law was the focus. After independence, you are aware, the constitutional challenge was turned down by the judgment of Supreme Court in Kedarnath's judgment, by putting very strict requirements of applicability of this provision, right? So, dissent, criticism of the government are not part of this provision. Nobody can force a person to love the government. It has to either come from within. He may be a detractor, he may be a critique, but he's not committing offense of 124A even if he expresses his opinion in public. Only there has to be an intention to incite violence, and there should be a propensity of causing violence. And on that logic, in Balwant Singh case later on Supreme Court, when person shouted slogans like Khalistan Zindabad, said this is not offense of sedition. Despite all this, the Supreme Court only a few years back agreed to reconsider the constitutional challenge to the provision. And General approach of law is that a provision is not unconstitutional simply because it is being put to wrong uses. Okay, misuse or abuse of the law is not a reason to strike it down. You strike down the action. That's what the courts always say. Supreme Court stayed a statutory provision which was in statute book for more than 100 years. When the government said we are reconsidering, they said there will be no prosecution on the basis of 124A from now on. So, very, very unusual situation and extremely novel approach by Supreme Court to stay the implementation of a central statute which was operating for more than 100 years was because its misuses were rampant. And I'm not on one state or another, one dispensation or another. States upon states have used this. So when a new law was being framed, one thought that this will be done away altogether. It has been brought in a different form, new avatar. And as you rightly pointed out, from the government to sovereignty of the state, and that's definitely a welcome change. But there are one or two provisions which are slightly problematic. If I can just see the exact provision.
152.
Yes. The remaining things are quite all right. Excites or attempts to excite the cessation, etc., or encourages feelings of separatist activities. And this, what I think, is very wide. If a particular state feels alienated, and if there is a thinker who says that should we not demand a separate state, by simply saying it, is he committing offense of sedition? And many of these things will play out over a period of time. But I'll expand later when we sum up the whole thing. But to put it very briefly, the state should not feel so threatened by people expressing their opinions unless there is a direct correlation between inciting violence. Ordinary offenses are there to deal with ordinary situations.
The law which said that 124A would apply only if it incites violence, will that same reasoning apply to 152 as well, that the threshold shall still be to excite violence, or whether this will have to be given a separate look?
Eventually, we might come back to the same situation, but the Supreme Court will have to restate it, analyze it, give the same interpretation, give the strict meaning, strict interpretation. But as I said, that till that happens, it's possible of misuse, one. And two, despite Kedarnath was 1960 judgment, right? In early 1960s. In 2024, we are still witnessing certain very loose applications of this provision. Then you ask for bail, then you get bail, then you face trial, then you are acquitted. As I said, process becomes a punishment.
Sir, speaking about punishments, there has been one major change, and there is introduction of a fresh and new punishment, is the punishment of community service, which has been there in other countries, but in India introduced for the first time. So what are your views with respect to this new punishment which has been introduced?
Certainly a welcome change. As you know, they are prescribed for very minor offenses. Something like a drunken behavior in public, misconduct in public by a drunken person, something like that sort, it is said. And two or three other similar provisions. And Section 23, I think, explanation in the BNSS says what is community service. Is service which will be beneficial to the community and for which the person will not get remuneration. So it's pro bono, it's compulsory, it's a punishment by itself. In some jurisdictions, I could read the literature where it said that it could be in lieu of punishment of imprisonment or a condition for probation. Here it's standalone punishment. So it's a novel concept or a new thing for Indian jurisdiction. It leaves the discretion to the magistrate to hand it down. What is community service is not clear. How long can it be given is not clear. So let's say a magistrate thinks that a person should serve water on a hot afternoon at a corner of the street to people who are passing by. It's a community service. And it will also bring in some sense of responsibility to a young man who has committed an act of indiscretion. But how long? Should it be for 1 week? Should it be for 1 month? And who is going to check it? Accountability or audit is going to be another challenge. You hand down punishment, but you have mechanism to see that it serves it out. These are a couple of things will over a period of time will need some more clarity. But correct step in the right direction.
In fact, one of the reasons why this was included, it said, is that because of overcrowding of jails and it's not necessary to punish some offences like the ones they mentioned. But eventually, the machinery will still have to be equipped for dealing with this. So there will be expenses and infrastructure required for this sort of punishment to be inflicted.
So now, coming to more of a practical difficulty which arises on a regular basis is with respect to the savings clause as to whether these penal offences have to be prospective and what happens, when will the BNS apply and when will the IPC apply for offences committed before July, however reported after July, which will apply. So there's been a sort of a debate as to what exactly will apply. So what are your views on the application of BNS as opposed to IPC if the offence is rather committed before July but reported after July?
More complex situation is going to arise in BNSS. Courts have already taken different views. I was speaking in Goa and I pointed out that the Goa bench has taken a different view from Rajasthan High Court. Completely different. One school of thought says that after 1st July, BNSS will apply only to FIRs which are registered after that. Some school of thought is that FIR may have been registered after that, but if appeal provisions are revision, etc. has come after the act has come, the new provisions will apply. But let's not go into it. So far as BNS is concerned, it is possible of a more simple formula. As you know, the Constitution says there shall be no ex post facto criminal legislation. Meaning, on the day offence is committed, if it is not an offence or if it's punishable by a lesser penalty, you cannot change it by retrospective law. Even law cannot be made to apply retrospectively. And therefore, in plain terms, BNS will apply to all offences which are committed after the act is brought into force. And all acts have to have repeal and saving provisions. Otherwise, a great legal controversy can arise. BNS, of course, repeals IPC, but saves all acts done before that or all liabilities created under it. Therefore, if an offence is committed, to my mind, prior to the BNS being brought into force, it will continue to be governed by IPC. To my mind, even if it is reported later, it would make no change. One small area of debate could be that if BNS makes a lighter provision for punishment or abolishes the punishment, would the situation change? In one of the judgments of Supreme Court, I don't remember, they said there cannot be an ex post facto criminal legislation which is harsher, where it's more beneficial. Can it apply or not? Okay? That's going to be one of the discussions. And that is why they said BNSS, you apply that provision of liberal bails after certain offences to even old cases. But that's a small area, there's some debate may be possible. Otherwise, it's very clear cut.
For example, we spoke about 377, which was an offence and not an offence now. So then what would happen if someone reports an offence?
Correct. So now that is going to be a debate possible.
So I think we've extensively covered most of the changes, at least the major changes. So what would be your concluding remarks? And you said at the start of the video that you'd like the viewers to form their opinion. So for all of us to form an opinion, what would be your concluding remarks?
So as I said, let the viewers judge for themselves whether at the outset what the government's viewpoint for bringing those objectives have been fulfilled or not. To my mind, as I said repeatedly, quite a few positive introduction of changes are there. So many changes were needed. With passage of time, we need a relook for sure. I've often wondered, was it necessary to bring the whole new law, or amendments in the existing law could have served the same purpose but created a lesser disruption? The courts will definitely give it a proper shape with the assistance of lawyers and judicial interpretation. And yes, the legislature will also see how these changes are working out. And surely we can expect some modifications, some corrections whenever errors are found. And courts will definitely have a very major role in shaping these new provisions and chiseling away wherever there are rough edges.
So I think that will conclude our episode.
Thank you so much. Really enjoyed.
Thank you very much, sir, for coming here. It was certainly an enlightening session for all of us. And thank you very much for taking out some time, sir, for us. And yeah, we are very grateful, sir. Thank you very much.
On the contrary, thank you to both of you. I thoroughly enjoyed your questions were extraordinary. They were very precise, they were very relevant, and I hope it'll interest all our viewers, including those who may not be directly connected with law.
That's our endeavor. Thank you, sir.
Thank you very much.